Welcome to the webinar, Does Asset Protection Really Work? This is presented by Lodmell & Lodmell and our affiliate attorney program, lodmellpartners.com. My name is Douglas Lodmell and I'm the managing partner and co-founder of Lodmell & Lodmell, along with my father, Gary Lodmell. I've been practicing in the area of asset protection since I graduated from law school over 17 years ago and have worked exclusively in this area. My father, Gary Lodmell, has been a business and estate planning attorney for over 50 years and was really a leader in the asset protection industry as he entered it in the early 90s, right at its inception. So we really do understand asset protection here. Why should you add asset protection? Well, one, your clients are already looking for it. I know because they're calling us and they want it. They would much prefer to work with you. They don't want to make this decision alone, and they really do want your support in implementation, integration with the planning you've already done. They want to work with you. So they're calling all around, I know, because the internet is really full of clients looking for solutions. And the number one reason I hear that they're calling is that their local attorney doesn't offer it. They mentioned it. So the question becomes, does it really work? And I can tell you, in practicing in this area for almost 20 years now, the short answer really is a resounding yes, but it's got to be done correctly. And it's got to be done in a way that allows you to get to that yes. So why does it work? Well, the overwhelming reason asset protection planning works is that it strongly discourages a plaintiff's attorney from seeing an easy target and encourages a reasonable settlement. That's the number one reason. In my experience, this happens over 90% of the time. This is the main point of asset protection. Yes, it's got to work, but 90% of the time it works simply by existing, simply by being there. It puts your client in a position where they can settle, where they can reach a reasonable settlement, because it takes what that plaintiff attorney really wants and just takes it off the table, which is an easy target, an easy settlement because there's $1 million sitting in the bank of my client. That's not sitting in the bank easy for a plaintiff's attorney to grab. Therefore, my clients have leverage. And 90% of the time, they solve these problems. To me, that is complete success. When you can solve your problem 90% of the time without actually having to go through the fight, that's success. And asset protection absolutely does that. Caveat: this works over 90% of the time only if the asset protection plan in place is seen by opposing counsel as virtually impenetrable, and your client and his counsel, which is you, skillfully manage how the plan is used and when and how it is revealed to the other side. You've got to play these cards properly. There's quite a lot of planning going on right now where it's, I call it the document approach. Basically, people are selling a document saying, oh, this is a trust. It has all the provisions and the caveats in it and all the right language, and it's filed in the right spot. But unless you play your hand properly, it doesn't mean it's going to work. I think helping clients understand that that is the critical piece to this whole plan is perhaps the biggest challenge, is helping them understand that it's not about the document. The document has to be right, but it's how we play it, how well we manage our hand, how well we play poker with our clients. This means that the planning must not have any obvious weaknesses or vulnerabilities that they, meaning plaintiff's counsel, feel they can exploit. And we're going to get into what the pros and cons of that is. When it doesn't work and settlement cannot be reached, the planning actually must work. It can't be a bluff. So it can't be a bluff when 90% of the time, I suppose it could be a bluff. But 10% of the time when called upon to be used, it can't be a bluff. It's really got to work. Okay. I put this in here, a brief history of asset protection, because I think it's really difficult for you to come into the asset protection industry today and make a good, clear decision about what would be the best options for your clients without understanding the history of asset protection, how we got to where we got. So indulge me for about 10 minutes in this webinar, and we're just going to go through, where we came from. up until the 80s, there really was no specific area law called asset protection. Most of the planning was covered under the guise of corporate planning, which really just meant the use of corporations to limit liability or shield assets, or it was done through estate planning. And in that sense, it was typically done through the use of spendthrift trusts to pass assets in a protected fashion, but to pass them to heirs. So, but by the mid 1980s, it was becoming apparent that dedicated tools and strategies to protect assets during a client's lifetime were really becoming necessary. Clients were asking for it, they started demanding it. The first of these tools were what we call the COPE entities, or the charging order protection entities. These were, of course, the limited partnership first, and then at the time, in the 80s, the brand new limited liability company. And then in 1984, little island in the South Pacific called the Cook Islands became the first jurisdiction to pass a specific asset protection trust statute, which allowed for a self-settled spendthrift trust. Now, there are over 24 international jurisdictions which have very similar statutes that were all based on that Cook Islands model. And we're going to talk about what is a self-settled spendthrift trust, because that is the definition of an asset protection trust. This was a revolutionary concept at the time, this self-settled spendthrift trust. And it was presumed by many that it was against the public policy of the United States for anyone to settle a trust for themselves with spendthrift provisions. It just kind of didn't make any sense. Not a single U.S. jurisdiction allowed for this by statute or by precedent. So it was just not something we had done in the U.S. And many commentators at the time strongly denounced the idea, refused to utilize this approach, and derided those of us who had started using this approach. So in the very beginning, in the 80s and 90s, it was a little bit tense as commentators. We could probably look up some of those old commentaries about how this is all going to come crumbling down. However, clients were very motivated, especially as the litigation was really exploding in the 80s. As the plaintiffs' attorneys finally figured out how to market themselves. They discovered outdoor billboards, they discovered afternoon television and advertising, and as we know, the litigation explosion in this country took off and frankly hasn't slowed down. But some planners, like ourselves, believed that this was not only allowable, but necessary given the dysfunctional state of our legal system and our clients' desire to protect their assets from the unknowable and unpredictable legal events and threats. We knew it. We knew that the clients wanted it. They were demanding it. And we believed that this would be allowable in the future. By the mid-1990s, asset protection planning really had become a hot area of law. We saw the launching of both the Journal of Asset Protection and the Asset Protection Journal, competing journals that were both focused on nothing but case and theory in this area. We saw the creation by the American Bar Association of the Asset Protection Planning Committee. In 1998, the public policy argument over can we really create a self-settled spendthrift trust in the United States was decisively settled when Jonathan Blattmacher helped draft the Alaska statute that became the first U.S. state to pass an asset protection statute that, guess what? Yes, specifically authorized the settlement of a self-settled spendthrift trust. So that really sealed the deal. It was very hard for someone arguing that the U.S. public policy is against this when we now have a state that has said it's absolutely fine. And today, we now have over 14, or we have 14 U.S. states, the most prominent of which are still Alaska, Nevada, and Delaware, which have all passed similar statutes, which are now making up the domestic asset protection planning, and this has become a huge area of law. And we'll talk a little bit about my experience at Heckerling this year and what's been going on in this area. Additionally, many lawyers and non-lawyer planners have jumped into the field and are offering a myriad of plans and trusts at virtually every possible price point out there. This has made it even more difficult for clients to understand their options and to make good choices. This is why they need you. They can't go to the internet and get good information. Actually, they can get good information. They can't discern what's good information, though, and what's poor information. And at the end of the day, they want to come back to you and say, hey, tell me, what's the real story here?
And that, for me, is your role as primary advisor to your clients. It's to weed through the field and assist your clients in choosing from only the best options and the most appropriate possible options. They want you to do this hard homework for them, and they want you to present them with, here's your options. We believe that to do this, you must understand the technical pros and cons of each major approach, as well as the practical application as it applies to your individual client needs. The technical is important. It's got to be technically, you have to understand it, you have to be able to explain it, you have to be able to defend it yourself. But you also have to be practical. You have to understand what a client can and will do and what they won't do. And this is where there's still some tension today in the asset protection community, and we're going to see that. So let's go to the technical. The primary issue you will have to diagnose for your clients is the choice between using an international trust or a domestic trust. Make no mistake about it. This is the key question that you are going to be asked. This is the key question that you have to answer for yourself. You have to decide where you fall on this. And it is not necessarily a cut and dry question. You're really going to have to understand the issues. And in considering this, I can share with you that your clients will be primarily interested in the following. One, how much control they'll be able to have. We all know that. Two, how effective the plan will be if called upon to work. Of course, that's why they're doing it. They want to know it's going to work. Three, the ongoing cost to maintain the plan. It's very important. They need to understand what it's going to cost and how comfortable they are with the jurisdiction you're recommending. And this is linked back to the control issue. So, whether it's Nevada or the Cook Islands, they're going to have to be comfortable with it. So let's talk about the international option. The pros. And I'm using the Cook Islands when I say some of the specifics here simply because that's the leading jurisdiction and we have to pick one in order to have a good example. The primary and overriding advantage of the international trust is that the trust jurisdiction will not recognize any other jurisdiction's judgments or court orders. This is the big one. This is why you would go offshore. You want to go offshore so that the offshore jurisdiction that has your trust or your client's trust and your client's assets will just say, I don't recognize that Texas judgment or that U.S. federal judgment, and you're going to have to come down here and you're going to have to try that case down here if you want us to hand over the assets. That's the biggest pro, and it's huge. To add to that, the statutory framework of the Cook Islands is ridiculously strong. So, for example, the burden of proof in the Cooks is beyond a reasonable doubt. We're attorneys, we understand what that means. We understand what a huge responsibility that is to meet that burden. Two, contingent fees are not allowed, so the plaintiff must pay for an attorney. He can't get his free attorney like he's used to here. And the attorney that's working on the case here certainly is not going to be allowed to go down there to try the case. He has to get an attorney that is licensed down there. Costs and expenses must be paid by the plaintiff to begin the case, including flying in the judge from New Zealand. And by the way, these are retired Supreme Court justices from New Zealand. They're kind of crotchety. They don't suffer fools lightly. They're not there to make any friends. So it's not an easy task. Number 4, plaintiff must file an affidavit stating the exact claim being brought, which is not amendable. So the idea that you could start a claim and get into discovery and start fishing and then find new claims and amend them doesn't happen down there. 5, court is encouraged to award legal fees and costs to the winner. So, and I say C number 1. So you're going into a system that you have to prove your case beyond a reasonable doubt, and if you lose, you're going to be assessed fees and costs, and your burden of proof is beyond a reasonable doubt. I'm pretty discouraged. I don't really think I'm going to even try that, and that's frankly what most people figure out. They don't want to try it. And 6, there's a 2-year statute of limitations before you, just to bring the cause of action, and that's reduced to 1 year if they're actually going to bring the cause around the issue of fraudulent conveyance. Continuing with the international pros. We have now 30 years of experience with the Cook Islands and several significant cases which support the effectiveness of the trust. And I've chosen 3 cases. There are many more than 3. I know some of the attorneys on this call are very familiar with this area of law, and there's other cases I could have chosen, but I believe that these 3 are important. First of all, FTC versus affordable media. This is an old one. It's called the Anderson case. It's important because you got to know this one. You have to understand this was really the first seminal case, and the FTC took it upon themselves to really break the Cook Trust. They went down there. They literally went down there 3 separate times. They did not succeed. The best they could do was they did get a Moreva injunction, which was basically they froze the assets. The clients couldn't get the assets, but neither could the FTC. And through the back channels, we know that the case was ultimately settled for about 10 cents on the dollar. And so the Andersons, which were not sympathetic people, they were crooks, they ultimately succeeded in protecting their assets. And the Anderson case really stands for the fact that even with a very poorly drafted trust, done with the wrong type of clients and handled almost the worst way you could throughout, still worked. U.S. versus Grant. Now, this is a much more recent case, and it's gotten a lot of press. And it's an interesting case because the IRS attacked the trust for a $36 million tax debt of the husband who had died. And the trust was set up and the wife was the beneficiary. And in round 1, it was really an unqualified success for the trust. The court found that the wife didn't have access to the trust because of the protection provisions. And they basically said, no go to the IRS. Round 2, she had a little bit of problem, and we're going to tell you why. And the third case is the SEC versus Solo. And this is an interesting case too, because again, it worked, but it worked with some bad facts. So the SEC attacks the wife's trust for SEC fines of the husband. The trust was funded by tenancy by the entirety assets, and the court found that there was a fraudulent transfer and held Salo in contempt because he signed off on transferring those tenancy by the entirety assets to the trust of the wife. Nevertheless, the SEC still hasn't recovered the assets, so the assets were protected, but bad facts. So let's look at them in a little more detail, because in my opinion, these cases kind of represent the worst case scenario and a poor use of the trust. And in each case, the trust was flawed in some fashion. So in the Andersons, they were criminals. They were literally running a Ponzi scheme of late night television commercials and bilking, not kidding, little old ladies from Pasadena. That was literally their target, to invest in these commercials, and they were just taking their money. They also remained as protectors while they were in front of the judge. They didn't ever get removed from that position, so they held much too much control. And so it was just bad facts all the way around. And again, it still worked. In Grant, Miss Grant was successful the first time because she didn't have access to the trust assets. But after she won that first round, she asked the trustee to distribute $221,000 to her children's account. The IRS grabbed that, ran back into the court, and said, "Hey, she said she couldn't get the assets. All of a sudden, the kids got $221,000." The court threw the book at her at that point. They said, "Oh, okay. Well, now that we see you do have some influence over this, we are going to absolutely prohibit anybody in this country from assisting you in getting these assets back." And that proved to be pretty effective because, frankly, there's now a court order that if anybody facilitates her getting money out of this trust, they now have trouble with the court. So the net effect is that she can't really get her assets from the trust here in the United States. But the assets themselves are still protected. The IRS hasn't succeeded in getting them. And as even some of the commentators have pointed out that this case is problematic from the International Asset Protection Trust standpoint, have noted, she's still free to go offshore and get this money. So, it's just a question of how effective is it if you still have the money and you still have your options open. And in Salo, again, we talked about the trust was created by tenancy by the entirety assets. The husband who had the SEC problem, signed over his tenancy by the entirety interest to the wife so she could create the trust. This all happened right after the judgment from the SEC. There was, as the court noted, a flurry of financial activity. And here's the irony. Um, the assets were already in tenancy by the entirety. They were already pretty well protected, and in Florida, no less. So, in one sense, had they done nothing, certainly some, if not all, of those tenancy by the assets would have been protected anyway. So, I think that was just bad, a bad fact pattern that caused for this. But the SEC still hasn't gotten any of those assets. So, again, it's one of those cases where it works, even though it really, the court didn't want it to work. It still has worked. I put, there's more full case briefs at loudmouthpartners.com. Okay, so let's talk about the cons of the international trust. The primary and overriding issue with recommending any foreign trust, and I guarantee this is 20 years of experience talking, is client comfort and control. Clients are very hesitant to turn control of their assets over to a foreign trustee in a very far away jurisdiction. This is especially true if the planning is truly being done prospectively and not during a time of crisis. So it's one thing if a client is calling you, they're feeling absolutely vulnerable and at risk. They're pretty open. They will start an offshore trust because they don't feel like they have a lot of options. But that's not the best client anyway. That's not really who you want as a client, is the guy who's running and is running from a judgment. You want the guy who's the doctor or the entrepreneur or the employer who just wants to be protected, who wants to make sure that they have a plan in place. Well, that's the guy who's going to be very hesitant to turn their assets over to a foreign trustee when there's not really anything pressing. And it's going to be a big deal. In my opinion, this is the one issue that has been the primary driver for the growth of the domestic asset protection trust industry. The fact that when you say a Nevada trust and a Nevada trustee, U.S. clients pretty much don't think about it because they're used to that. They're used to the concept, or Delaware, or even Alaska. It's familiar to them. They feel safe. They understand it. It's still domestic. And that's really, in my opinion, why the domestic asset protection trust industry has exploded. Is because it's easier to sell, and it's much harder to get a client to choose an international trust when he feels like he can get the protection with a domestic trust. Whether he can or not, we will see. A secondary issue is the maintenance costs and expense of a foreign trust, although in many cases the domestic trusts are equally as expensive to maintain. And additionally, there are increased filing and disclosure requirements for foreign trusts, which include Form 3520, 3520A. These are informational in nature. Nevertheless, clients are pretty resistant. If they have to file more IRS forms, they don't like it. And now you add to it the FACTA disclosure forms. And of course, if there's an offshore account, you have to have the FBAR forms filled out. There's some pretty steep penalties if you miss your FBAR filings. All these things are just more features that make clients resistant to choosing the international option. And it's a big con. Clients are very resistant. And if you want to really promote these types of trusts and do a lot of them, these are things you're going to have to deal with, because even sophisticated clients are resistant to this. They really are. Okay, the domestic option. What are the pros? Well, the primary and overriding advantage of the domestic trust is that clients have much less resistance to a domestic trust in Nevada or Alaska or Delaware. They're just more comfortable. They're used to it. It doesn't seem scary to them. There are no IRS filing requirements in the form of the 3520 or 3520A because we're talking about a domestic trust. Overall maintenance costs are likely to be less, due primarily to the elimination of the IRS forms and their preparation costs. And domestic trustee fees are similar in structure to the offshore. In other words, $2,500 to $3,500 a year. Of course, there's all sorts of price points, and we'll talk a little bit about it, but this industry has really been confused because there are internet providers who are not attorneys who have hooked up with what I would call a trust mill, and are doing, asset protection trusts for $7,500 a year and, $500 a year of maintenance. And these are not what I would recommend for a client. But it's important you understand that that's out there. There's no FBAR or FACTA forms if no offshore account is used. So these are pretty big pros. What are the cons? Well, the primary shortcoming of the domestic trust is really simple. Article 4, Section 1 of the U.S. Constitution states, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. In other words, full faith and credit clause is precisely the opposite of the primary benefit of an international trust, which is non-recognition of any judgments. That's a pretty big deal, folks. I mean, this is the key point. Is Nevada really an asset protection jurisdiction for California? I think we're going to see that it's not. We also have conflicts of law issues. The governing court may simply decide not to apply the law stated in the trust. So you might have a California case, they've done a Nevada trust, and the California court says, well, we're just going to choose California law, and California law doesn't allow for a self-settled spendthrift trust. And there you go, you have it undone. Statutory exemptions. Even within the various domestic asset protection trust statutes, there are extensive exceptions, such as certain tort claims are accepted, alimony and child support, property division and divorce, pre-existing claims, liability from fraud, liability from criminal activity, tax evasion. Even if these exceptions seem reasonable to you, as an attorney, all they do is serve to provide a whole bunch of ways in which a result-oriented judge can have a reason to break the planning. So, of course, all those seem like reasonable exceptions, but if you're drafting a plan for a client, it's just another weakness of the plan. DIPTs have been around less time. They're only 1998, so they have been around half as long as the foreign trust. And I've chosen 3 more cases for us to look at in the domestic realm. So Batley versus Mortensen, 2011. Mortensen is an Alaska resident. He established an Alaska DAPT, and he was solvent when he did so. He funded it with a $60,000 piece of property and $100,000 of cash, which was a gift from his mother. Later, due to medical expenses, he declared bankruptcy. The court used Section 548E to include the DAPT assets, and the result was that the trust had a complete failure. In regard to Huber, this is 2013, so very recently. Huber was a real estate developer in the Pacific Northwest, and he settled an Alaska domestic asset protection trust in 2008. I think you can put it together, right? Real estate developer, 2008. So he already had seen the writing on the wall. His company was having trouble, and he took some good assets and he funded this trust, and he let the bad assets fail. He ultimately tried to use the bankruptcy court, and they again used Section 548E to include the assets of the trust. And Alaska USA Trust Company rolled over about as fast as any trust company could roll over. They handed the assets right over, washed their hands of it. Again, result was complete failure of the trust. And the third one I chose was Kilker versus Stillman. Stillman is a soil engineer, and he was in an industry which, soil engineers get sued fairly regularly if there's a problem later with the building that is constructed on their report. And he established a Nevada domestic asset protection trust when he had no claims or liabilities. He was in California, and the California court later concluded that just the funding of the trust was itself a fraudulent transfer under the California Uniform Fraudulent Transfers Act, because liability in his industry was reasonably foreseeable. Of course, the result was a complete trust failure. This is a scary result, folks, and let's look at it. To me, these cases represent the first in what I expect to be a continuing trend of failed domestic asset protection trust cases. And except for Huber, these cases actually have pretty good facts, and they still failed. So let's look at it. Mortensen, he was an Alaska resident. He used Alaska assets. He set up an Alaska trust. He was solvent when he settled the trust. A majority of the trust assets were in the form of a gift from his mother, and nevertheless, the courts included the assets, and his trust failed. That's just bad facts. I mean, that to me is just a death knell for domestic asset protection trust. Two, Huber. Huber wasn't quite as good at facts. He settled the trust when the handwriting was on the wall. His timing was very poor, but his choice of jurisdiction was even poorer. His planning was really doomed for failure. However, by choosing a domestic asset protection trust, he really ensured that he gave himself no leverage. There was no chance that he could use the leverage of the trust because it just completely failed. And then in Stillman, this is the one I think is really the most concerning, because basically what the California court said is that just setting up the trust itself was a fraudulent transfer under CUFTA. So they just said, even though he had no issues when he created the trust, the fact that he created the trust and he could reasonably expect, or that lawsuits were reasonably foreseeable in his industry, was enough for the California court to say it was a fraudulent transfer. That's bad. That to me says basically, if you're a California client, don't use a domestic asset protection trust because it's never going to work. And so, that's why I put these cases under the cons. I told you I would give you a slide on Heckerling. And I went to Heckerling this year, as I do many years. And asset protection is getting a more and more prominent place in Heckerling. And for those of you who don't know, Heckerling is the biggest estate planning conference in the Southeast. It's held in Orlando. It's the University of Miami's conference. It's an entire week long, and it is absolutely packed with fantastic information. There were 3 different talks on nothing but asset protection. And so it's gotten a prominent place. And then on top of that, there was really an overriding message from many of the speakers that weren't speaking specifically on asset protection. And here's really what my takeaways were from this. As an estate planner, you better be familiar enough, at the very least, with asset protection to be able to inform your clients that there are options available to them. In other words, you can't just be ignorant. You have to at least be able to say, asset protection exists. Here are the options. Here's the pros and cons. And I think you should actually be doing more than that. I think you should be providing it. The other big overriding message was that there are some significant issues with domestic asset protection trusts. I heard the comment made at least 3 different times by 3 different presenters during the conference, and it was quite the buzz in the room. The domestic asset protection trust industry was pretty well represented in the booths, and there was more than a little tension between the message from the stage, which was really down on the domestic asset protection trust, and what the domestic trust companies from, they were from South Dakota, Nevada, and Alaska. They were all over the place. And so, there's some real disparity in the industry right now. So here's my summary. I won't do a domestic asset protection trust. Based on the case law, based on those 3 cases alone, it's enough for me to say, why would I do that? It doesn't make any sense. I certainly don't want to be the lawyer on the case for Stillman or Huber. It just doesn't make any sense to me to use a domestic asset protection trust, and so I just don't recommend them. Nevertheless, I understand, as well as anybody in this industry, that there are many clients that simply will not do an offshore asset protection trust, and they will go without protection versus doing an offshore trust when waters are calm. And again, there's a distinction. If someone calls and they're really stressed out because they feel like they're about to have a liability, of course, they're going to do one. they're open because they're under threat. But that's not the clients I want. I really don't want those clients. I want clients that are in your office that are good, solid clients. They're doing their estate planning. They are concerned. They have employees, or they're a medical professional. They're an entrepreneur. They've had a partner that got sued, or they saw a colleague go through a bad lawsuit, and they just want to be safe. So I understand that those are the best possible clients, the ones that just want to have it in place, and that's why we created a hybrid option that really combines the best of both worlds. So let me tell you what your clients really want, and this is a little bit of a comical slide. What your clients really want is a plan with no additional IRS or government forms, no tax returns, no reporting, no disclosure, nothing. They want a plan where they will never have to give up any control whatsoever. They want a plan that is absolutely bulletproof, and frankly, they'd like a written guarantee from you that it will work no matter what. They want a plan that is hyper flexible, that never closes any doors or options for them. And by the way, it should save them all the possible taxes in the world and make sure they never pay any income or estate tax. And it should have no ongoing expenses or fees whatsoever. And it should be free. Well, almost free. I mean, they're willing to pay you a little bit because they don't want you to not be able to feed your kids, but not very much. Is this possible? Well, of course, the answer is no, not really. But some of it is. And more than you think. And this is where we've developed what we call the Bridge Trust. And the Bridge Trust is a domestic grantor trust with the necessary spendthrift provisions which allow it to trigger in the event of an emergency. It is pre-wired to the offshore jurisdiction, allowing for a truly unique set of benefits. So this is what I refer to when I say it's a hybrid trust. It really is a trust that is planted in both jurisdictions. It's a domestic grantor trust for tax purposes. The settlor can maintain direct control of the trust as the trustee. There are no RS filing requirements, not even a 1041 for the trust, because it's just a grantor trust. It's treated from this perspective just like a revocable living trust. It's domestic for U.S. tax purposes. It can hold and protect the settlor's primary residence with no loss of the homestead exemption, home mortgage interest deduction, or tax-free capital gain, which is important for a lot of clients. It can hold an interest in all of the settlor's other assets, either directly or through the more familiar tools of corporations, partnerships, and limited liability companies. The trust is established, and we register it in Belize to create a rock-solid inception date and give our clients an actual offshore trust certificate, even though it's still a domestic trust for tax purposes. And then it is also further registered with Southpac Trust, the leading trust company in the Cook Islands. And they play the role of special successor trustee, and they will accept the trust if it ever needs to be triggered in the event of a real emergency. Ultimate protection is in the Cook Islands, and the Bridge Trust will be recognized as of the date of the original filing in Belize, regardless of when we trigger it. So what we're really creating is we're creating a trust that is simple and easy to maintain, that is funded, that has the assets of the client in it, but that is not truly triggered until and unless the client needs to. And again, doing this for 20 years and having thousands of points of reference, I can tell you that it is less than 1% of my clients have needed to trigger the trust. That does not mean that only 1% of them feel like they use the trust. I would say it's exactly the opposite. 99% of them feel like they use the trust. Because what is the purpose of the trust? The purpose of the trust is for them to feel protected so that they can go on with their life, so that they can do their work and they can make their money, that they can practice medicine without fear, that they can hire and fire employees without fear, They want to live their life knowing that they're not going to lose everything. This plan creates that, but it does it in such a way that there really is the minimum amount of hassle, maintenance, and barriers up between you and between them and choosing to go forward with the plan. So it is extremely effective. And again, we've been using this trust concept for 20 years. We've done thousands of these trusts, and it is in the video. This is the trust that those clients are talking about. This is the trust that gives them that level of comfort and security. And it really has been a fabulous hybrid invention of taking the best of the domestic, which is the simplicity and ease of maintenance, the comfort that the client wants, but combining it with the truly strongest possible protection if we ever really have to use it. Annual fees for this are also only $14.95, so much less than even the domestic only option. So why would you want to work with Loudmail? We have a proven track record of 20 years and of thousands of asset protection plans in place. This gives you access to the Bridge Trust and to the necessary network of professional relationships, connections, and support systems that are required to make it work. We have a highly developed and dedicated affiliate support program. We have an expanding and growing community of planners at your disposal, including support and coaching on how to market asset protection, which I have spent a lot of effort on and become quite good at. And you know, the goal of the Loudmail Partners Affiliate Attorney Network is to really create a community. I know that I have clients and they move from one state to the next, or they have a second home in a second state. I want you to have access to attorneys that are familiar with the plan that you've put in place because they're connected to the same network and have access to the same plan, and that you could pick up the phone and refer a client that is, let's say, you're in Georgia and your client is going to move to California and they're going to need an attorney there, or you need to recommend somebody. You know, you can find somebody within this network that will support the planning you've done, understand the planning you've done, and be able to competently help your client as they move. We handle the heavy lifting of the drafting, filing, and maintaining of the plan, freeing you up to really work with your clients and to do what you already do well, which is the planning you do, the business planning, the estate planning. Asset protection is complicated enough and definitely important enough that you've got to do it right. But you don't necessarily need to go back to school and spend the next 3 years learning it from scratch. By partnering with us, you can basically be up to speed immediately. There's virtually no uptime for you to get moving. And you can represent that your planning you offer is tested and in partnership with the nation's leading asset protection law firm. And this allows you to strengthen your relationship with and retain your clients and not have them go outside of your office for this support. I think that's critical. I think that's what you want. And our goal is to give you that support. So the best way to begin is really to call and identify a client and set up a conference call. And together we'll do a full analysis with the client. We'll make a recommendation that makes sense, and then I'll help you to engage the client to the greatest extent that I can. If you want just more information, you can go to Loudmail Partners. This is a website that is dedicated to the affiliate attorney program of Loudmail. It is expanding. I'm continuing to put lots of effort into it. It will be growing, and there will be more resources and materials up there all the time. There's case law or a case summary section where I briefed all of those cases we talked about today, and I will continue to brief them. If you're already an affiliate attorney, I welcome your input on that website as well. We'd love articles, support, case briefs from all the attorneys. Again, the goal of this program is to develop a robust network of attorneys that are there to support each other. So that's the key. So that's it for this webinar. I will be happy to take any questions if you want to type them in, or if anybody wants to say anything, you can raise your hand and I'll unmute you and be happy to listen to any questions as well. I see one question. Let me read it and then I'll answer it. Okay, so Ed, great question. An increasing percentage of my work involves business exit and transition planning for owners of privately held businesses. Speaking generally, are there particular issues you've experienced in the interplay of asset protection trust strategies and business exit planning? Um, I'm glad you brought this up. Business planning, business exit planning, the sale, transition to your business is probably it's definitely one of the top three reasons why my clients have had to trigger their plan. The sale of a business is one of the riskiest moments in the life of that business. It today almost always results in a future lawsuit, and it's sad. So yes, the answer is that if you have a client that's selling a business and they don't already have an asset protection plan, that is the moment in time they need to get an asset protection plan because they need to put the proceeds from the sale of the business into the asset protection plan because the risk that are going to get sued over that sale at some point in the future are fairly high. So the answer is yes, absolutely. And if that's a big part of your business, I would certainly be bringing up asset protection as part and parcel of one of the topics that you really need to discuss with them when they're selling the business. So great question, Ed. Thanks. John is asking, how does the plan interact with the existing estate plan? Um, Thanks for asking that, John. You're right. I didn't discuss it. The way that we structure this plan is that it works in conjunction with the existing estate plan. This is different than the way many people do their asset protection trusts. Um, what I do is we have our trust look down through the estate plan. So we do not do the estate planning or the dispositive provisions inside of the asset protection trust. Why not? First of all, I think the estate plan needs to stay as the estate plan and it needs to be done specifically as an estate plan. It needs to be flexible, it needs to be revised over the years, and it needs to be state specific. And so it's very important that the estate plan be done by you in the state that your client is and considering all of the issues with the state. A lot of the asset protection plans being sold today are also purporting to be the estate plan. I think that's dangerous. It's too easy to miss an important state issue or estate planning issue, and there's no need. The asset protection plan, the way we do it, the Bridge Trust is actually directed to look right to the estate plan or look to the revocable living trust. So at the death of the client, the Bridge Trust looks at the revocable living trust and says, use those provisions, distribute through the revocable living trust, or if there is an asset protection reason why you cannot distribute to the revocable living trust, for example, the client dies in an accident, leaving the estate with a potentially huge liability, then the asset protection trust is directed to adopt the provisions of the revocable living trust directly and act as if. So what that means is that we don't have to go monkeying around with the asset protection trust all the time. We don't have to keep changing it. It's not revised. I like the asset protection trust to be put in place and to age and to get old and cold. I really don't want it to be something that is constantly amended, changed, revised, updated, because again, it just shows the nature of the trust and allows the court to read into that. So it's just much easier and it allows also for them to be done independently. And a lot of clients have done their estate planning and it's just much easier to have that as a separate consideration. So, but thanks for asking that question. That is a great question. Okay. Well, this has been a great pleasure. I invite any and all of you to call me directly at any time. You can reach me at 602-230-2014. You can also reach me directly at my email, which is just my name, Doug, D-O-U-G, at lodmell, Lodmell.com. And the next webinar, we are going to talk about how to actually market your practice. How you can use asset protection as a primary marketing tool to help you in identify and engage new clients. I will, if you're on this webinar, you're already on the list, and I will send you out the information on the next webinar. It'll be in approximately 6 weeks. And in the meantime, I really invite you to call me or contact me directly if you'd like to discuss an individual client. or if you have any questions at all about anything we've gone over here, whether it's technical, practical, or theoretical. I really appreciate all of your attention, and everyone, I hope you have a great week. Thank you for attending, and we will see you next time.